During the COVID-19 pandemic brought some couples closer together. For others, it's led to separations and even divorce. And when it comes to common law breakups, the division of assets and debts can be a bit complicated. Joining us this morning is divorce lawyer Stuart Zuckerman with more on this. Good morning. Thanks for taking the time this morning.
Morning. Thanks for having me.
So what defines a common law spouse and what entitlements or obligations do they have upon a separation?
Well, if a couple has lived together in a spousal-like relationship for 2 or more years, then they're considered to be common law spouses in BC, and each spouse has all of the same entitlements and obligations regarding spousal support or alimony, property division, and asset and debt division as do married spouses.
Okay, so what happens if a couple separates, but some assets like the family home, a business, RSPs, or other investments are owned or only in the name of just one of the spouses?
That does often happen, but it makes no difference who the asset's name is in or who the asset or the business or home or bank account or debt is registered in. All assets and debts that were accumulated from the date of the couple's cohabitation to the date of their separation are subject to the starting presumption of an equal 50-50 split, unless an equal division would be substantially unfair or if there's exclusions.
Okay, so you did mention substantially unfair. What would be an example of a factor that could make equal division substantially unfair?
So there is an extensive list of factors that is in the Act. One of them, for example, would be if one of the two spouses received a substantial gift or inheritance or a personal injury award for pain and suffering during the course of the marriage. Those funds may be argued to be excluded from the equal division of assets. Or if one spouse contributed significantly to the career of the other spouse at the sacrifice of their own career, that may also lead to substantially unfair finding.
So what if one spouse owns a property or an asset like an RSP or a pension months or years even before they ever began living with their spouse? Is it still all 50-50?
So this has to do with the law of exclusion, and no, it's not all 50-50. The law does allow the pre-owning spouse to exclude from the division that portion of the equity that existed from the day before cohabitation. However, any growth in the equity or in the debt over the course of the cohabitation onward is subject to the equal 50-50 division presumption.
I know if a couple is separating, the property, the real estate becomes sort of a contentious issue, I'm sure, when it comes to division of that asset. And prices have been skyrocketing lately when it comes to real estate. So what happens to spouses who separate and then their home equity or investments increase or decrease in value in a big way after they have indeed split up?
Well, we've seen a lot of that in the last 2 years, and generally speaking, all post-separation increases or decreases in equity in the assets or in the debts that are caused purely by market forces are shared or borne equally by both spouses, unless it can be shown that the actions of one of the spouses directly cause the increase or the decrease, in which case the court may reapportion the asset or the debt in favor of the spouse who caused the increase in value.
And what should a separating couple do if they have questions or concerns and they're really not sure what direction they should be taking?
Well, the big thing is don't rely on legal advice from friends or family or Google for that matter. Some firms like ours do provide completely confidential, no obligation, free initial consultations where you can meet with an experienced lawyer and get all of your family law questions answered without incurring any fees or any obligation to incur further expenses if you don't want to.
Yeah, good information this morning. Thank you, Stuart.
My pleasure. Thanks.